Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. It's my privilege to review a book which I'm very fond of. It's one that I've read over the years. It's Goff and Jones on Unjust Enrichment, now in a 10th edition. It's been edited by a number of people: Charles Mitchell, King's Counsel, Paul Mitchell and Stephen Watterson. And it's from Sweet and Maxwell, the Thomson REUTERS company, and it's part of the Common Law Library. I've given it a title which may be a bit controversial for some, but I've said growing interest in this element of greed, because that's what unjust enrichment is really about. Now, I have had a number of cases involving allegations of unjust enrichment in a whole range of civil matters that I have dealt with. Quite often they're only a passing part of what's a much bigger overall piece of litigation. But unjust enrichment is, as it says, a good indication. It's unfair and people should not be allowed to make a profit out of other people unfairly. And basically that in its simplest form is what the book is about. Let's look at it first of all. It's a heavy book, well known to many people. There we go, there's the spine. You can see the Common Law Library, and then all of the various things, Sweet and Maxwell at the bottom. Nothing on the back. Then you get to the actual book itself. Very much the house style of Sweet and Maxwell. You have the paragraph numbering for each of the bits of the index. It's not a particularly big index. It could have been bigger, I think, in some respects. Although I found what I was looking for quite easily. The legal taxonomy mentions that, in fact, tells you how it's structured, and it also mentions that it's by the paragraph numbering. And you can see chapter 40, the last chapter, you can see the paragraph numbering there, and then there are extensive footnotes throughout what is well over 1,000 pages long. Now, the front of the book, here we go, you've got the Common Law Library listed there. There are really... These are the cornerstone of the common law. These are where the law can be found in its various forms in the various books. And this particular one, you can see there's the front page there. It's a heavy book too. You can see the first edition appeared in 1966. What's quite nice about this is they give you the dates of when the editions appeared. So you've got some idea of the history of it and who's been involved over the years with the actual book, because it's obviously a print book, it's an e-book, and it's obviously a very substantial work. The preface starts: 6 years have passed since the last edition of this work, and the law has moved on as a result of important new decisions. I haven't been involved in any of the ones mentioned here, but certainly these are areas which are raised quite regularly now in court. The most prominent, of course, of these important decisions have concerned a series of claims to recover money paid as tax under English legislation, which was later found to be incompatible with the European Union Treaty. And again, it goes on and gives a lot of information about some of the case law. And then that, in fact, was written, the actual preface itself was written in September 2022. I'm recording this in 2023. I've had the book for some time, but I've been using it, in fact, and actually reading through it, because there's a lot of it. There's the content section. You can see how that's structured. Part 1, Introduction. Part 2, Justifying Grounds. Part 3, Enrichment. Part 4, At the Claimant's Expense. Part 5, Grounds for Restitution, always the important, the remedy. And then you move on from there to part 6, defences, and then part 7, remedies specifically, right at the end. 40 chapters in total. Then you've got the tables of cases, and there are a lot of them. They go on for quite a way. As I say, you've got a very substantial number of cases, and then you've got the table of statutes. You can see there. It's well over 1,000 pages in total. So you've got the statutes. Then what you do have after that is some statutory instruments as well. And then after that you get into the book. As I say, it's split into different parts. Part 1 is the introduction, and what you've got is a structure. There is the introduction. You can see the paragraph numbering, and you can see the very substantial footnoting. It starts off saying, the modern English law of unjust enrichment developed as a law of restitution following the decision taken by Robert Goff and Gareth Jones in 1966 to publish the first edition of this book, which was given the title The Law of Restitution at that time. Obviously, over the decades, things have changed. I mean, I remember it from my studies. I've been involved in law for over 50 years, and I can say now that I remember it as restitution, but of course today we call it unjust enrichment. And you can see how the book runs through. It's a heavy book, and again you've got a whole range of important areas. Mapping of the law of contribution and reimbursement. There we go, which is an important point. I think that's, when it comes to an argument, and I used this particular part of what was in this book for a case I had recently when I was arguing about equity and how equity can in some cases step in when there are really serious problems. But beware, equity is not quite the be-all and the end-all that some people would like us to think, because at the end of the day equity does follow the law. Just remember that, even though one can always try, in terms of advocacy, the argument about fairness. So what do I say? What a book. Jones and Goff, as I call it, is now in its 10th edition, and it remains the leading work on the law of unjust enrichment. Successive editions have played a major role in establishing the central importance of the subject of what was restitution for private and commercial lawyers, and developing its key concepts and principles. And we now have this latest offering from the new editors. Obviously, as I indicated before, we've had previous editors which have been listed, but the 8th, 9th and 10th edition are by these gentlemen. That's Charles Mitchell KC, Paul Mitchell and Stephen Watterson. Now what we've got here is a text which is comprehensive in its coverage and written by highly respected scholars who explain all the rules governing claims of unjust enrichment, and they discuss how these can be applied through detailed examination of the case law. The case law is very substantial. I don't know how many pages, probably nearly 100, something like that. But there's a lot of case law. The book is frequently cited in courts. I used it myself recently, and obviously that's both in the English courts and the Commonwealth jurisdiction. And as it says in the blurb, it continues, quote, to signpost future development in the field. And that's really, I think, what the original author, Robert Goff and Gareth Jones, wanted to do, because the whole purpose of it was we started off with restitution, which is what we knew it as initially, and it's grown a bit because of changes that have taken place. Now, for this edition, what we've got is key features which cover the following: an analysis and explanation of the theory, principles and practical application of unjust enrichment. What the authors do is they show how the rules can be applied by the courts through detailed discussion of case law. Again, very helpful. I didn't use it as much as I would have liked in the recent case, or in fact several cases I've had, but I was keen to try to press certain points home. It's well structured in the sense and organised in accordance with the precepts established by the senior appeal courts, examining the following: when claims are barred because the defendant's enrichment is justified by a legal ground, when a defendant is enriched, when the enrichment is acquired at a claimant's expense, that's one that comes up quite often, when the enrichment is acquired, the enrichment is unjust, what defences are available to a defendant, and what remedies can be awarded. As I've indicated before, the remedies quite often are not quite as generous as we would like them to be. Now what we've got here is a combination of lucid explanation of theoretical concepts together with a practical set of pieces of advice on pleadings and so forth, which again I found quite helpful. It does rely quite heavily on the work of practitioners, and as I say, is quite regularly cited in court as Goff and Jones, and it's been written by a team of real experts, and I thank them very much for what they've done. And of course the new 10th edition is completely up to date and contains detailed discussion of the important decisions since the 9th edition came out. Several chapters have been wholly or substantially rewritten to take account of significant new cases from remote recipients, the problems, recovery of benefits in those circumstances, the recovery of benefits transferred on a condition that fails, that obviously happens as well, the recovery of ultra-virus payments, that's beyond the powers payments, by public bodies, again an area that's quite substantial, the limitation rules governing claims in unjust enrichment, and interest awards on such claims. Again, that's really quite important when one is looking at what you're actually seeking to get from the other party in the litigation process. The 10th edition has 6 points which I think are really quite important in relation to when you're making a claim for unjust enrichment. There are other books available, but this is the fount of knowledge, if I can put it that way. It explains how a claim in unjust enrichment can be precluded where a defendant's enrichment is mandated by a statute, a judgment, natural obligation or a contract. Also, there's an analysis of the principles governing the identification and valuation of enrichment, and it explains how these apply to claims for different types of benefit. And finally, it considers the requirement that a defendant's gain has been acquired at the claimant's expense, and that is actually quite an important area, because sometimes it can sometimes be looked at in a different way, but clearly that is a problem, because at the end of the day, the concepts, forget about the common law here, the concepts in equity are fairness, and frankly people shouldn't be able to make a profit out of something that is clearly unjust, and that really is the whole basis of where we are at the moment. The edition, as I understand it, was published sometime late 2020, probably around about December, but this is actually the book itself again. Let's have a quick look at it, opening it up in the middle, mapping out the contributions we looked at, money paid as taxes and other levies that are not due. An important area, because one of the problems today with a lot of litigation is that you really do have a very substantial amount of detail to consider. So you have general principles, then you have to get down to things like taxation and the other levies that are raised. This deals with specifically with social security in this particular part of the book. Then you've got counter restitution there, which is again an important area, and passing on common law. Now that is an important area, because that again in terms of litigation does crop up rather more frequently than people sometimes realise. But I'd like to thank the authors very much, Charles Mitchell, Paul Mitchell and Stephen Watterson, and I'd also like to thank Sweet and Maxwell for continuing to give us the excellent common law library. You make our lives a lot easier with these books, and I'm very grateful for everything that we get from you, because this is where the law is. It can be in the cases, but this is actually where the law and the rules are stated, and I think these are cornerstones of the common law. So thank you very much to everybody involved. Bye bye.